The next case is In Re Smith Minors. This is a 15-minute mini oral argument on the application. Mr. Pinto, you can reserve time for rebuttal, but we like you to try and keep track of that yourself. And you may proceed if you are ready.
Yeah, thank you, Your Honor. And may it please the court, Timothy Pinto, on behalf of Brian Smith, appellant father, I'd like to reserve 3 minutes for rebuttal. I see Ms. Bergmann says she can't hear anything, so I think I'm supposed to wait.
Yeah, please do, and we'll stop the clock. Sorry about that. Let's make sure she gets...
Your Honor, can you hear me?
I can hear you. Can you hear me?
Yes, I can now.
Okay, switch the audio. Great, we're all set.
Everything was deathly silent, and I wasn't wondering what was going on here, so I'm sorry.
I spent the entire first argument on unstable Wi-Fi, so I understand. No problem. We all I did was welcome you both and remind you that it's a 15-minute mini oral argument on the application, and Mr. Pinto is going to reserve, I think he said 3 minutes. With that, we will return to his argument.
Thank you. Yeah, the issue today is simply when a trial court can step in and take jurisdiction in a child welfare case on the grounds of absence from school, and specifically whether they can do that without a finding of any harm or impact on the children. And that is the record in this case. The trial court systematically dismissed each and every allegation in the petition until it came to the last one, which was that the children had attended 75% of school days and the school average was 85%. And there was no testimony of any harm to the children. The only testimony was that one child was at grade level, and there was no testimony at all about the other child. And the statute doesn't allow that to be a finding of neglect. The statute defines neglect to be harm to a child's health or welfare. The department does not consider excessive absences to be neglect. If they receive a call about excessive absences, they don't even open up an investigation. And so the trial court judge needs to actually make a finding of harm, and they do this all the time in neglect cases. They have to make a finding not just that the parent has done something wrong, but that it's impacted on the children in some way. And they have to make an individualized assessment. The error that the trial court made here was presuming that just missing school alone constituted harm. Judge Reardon said it right in his dissent. He said that ideally students wouldn't miss school, but the facts of this case may be more reflective of the educational condition of a great many school-age children. And as we said in our brief, we cited some stats from 2017. This has huge impacts on the state of Michigan families. In 2017, over 230,000 children were chronically absent. I'm positive that those stats are much worse today during the pandemic. And it impacts families, especially those suffering from poverty. My client's situation is a typical example. He and his wife lost their oldest child 6 months before this case was opened. And then he had a bunch of health issues. He was hospitalized a number of times, and he struggled to get his children to school. But that alone cannot be a reason to find neglect. And with that, I'm happy to answer questions.
Thank you, Mr. Pinto. Justice Bernstein will start. I think Justice Bernstein is muted. Larry. There we go.
Thank you. Good morning, counsel. I just have a quick question. And, as I follow your argument, are there any tenets of child rearing that are considered to be sacred in terms of, ultimately that these are certain specific things that are required for child rearing that, if not followed, would fall under the jurisdiction of a court?
I'm struggling to think of any where you could say there's neglect if you can't also show not just that they didn't follow that tenet, but that there was some negative impact on the child. Now, there may be a lot of things that are going to pretty directly impact the child, but there has to be some evidence either from the child or from the worker, in this case from the teacher, that shows that this is somehow impacting the child. But that's actually part and parcel of the statutory definition. There must be harm to the child. There's nothing that's per se always going to constitute neglect.
I see. And just one other question. When you're dealing with truancy, the issue is truancy is still seen as, in many situations, truancy, and I do recognize and completely understand the challenges and hardships that, people are facing currently, but how is truancy considered, if a person is consistently truant, what is is that considered, I guess my question is that, how is that valued? Is it considered a misdemeanor? Is it considered is there any type of culpability that comes out of consistent truancy?
Yeah, thank you for that question. Yeah, ironically, there's a specific statute that Michigan has. It's MCL 380.1581 that talks about truancy and how the state handles it. And then it sets up a procedure. It's a misdemeanor. It sets up a procedure that an officer can be given the power to investigate when they hear that there's excessive absences. Ultimately, they can issue a notice to a family that the child has to start coming to school. And if they don't, after that notice, then there can be punishments, including fines or even some jail time. Ironically, this record doesn't even support a finding that the family violated this criminal statute, let alone that they could remove the children from the home.
Okay, and I have one last question. Just in terms of the far-reaching implications of this case, what would the going a little bit beyond this case, with the implications of COVID, what has ultimately, and I guess I'll ask this of the other side as well, what has been the policy in terms of how courts have proceeded as it pertains to people who might have consistent absence due to the fact that they simply can't learn online?
Yeah, I wish I could answer that simply. It's a big policy question. I think that for our purposes, in this case, the basic rule that you're going to have to show some actual negative impact from the absences still
Right.
helps courts, gives them the guidance they need to resolve the next question that maybe is COVID related, where you compare how was the child doing before these absences started, perhaps compared to their peers. And so it's still possible that even in the COVID era, there could be a finding that a child has been neglected if what the parents are doing is impacting that child much more than other children in their peer group. So it's not impossible to make a finding of neglect, but it needs to be an individualized assessment of how is this impacting that child.
Thank you, counsel. I have no further questions.
Justice,
No questions, thank you.
Justice Cavanagh,
I have none.
Justice Welch,
No questions.
Justice Zahra,
Questions?
Justice Viviano.
I have a few questions, counsel. I know that neglect, there's a statutory definition for us to look at, but before we get to the statutory definition, generally speaking, when we think of neglect, someone who neglects something, that means that there was something they were supposed to do that they didn't do. And I'm just wondering, generally, what expectations do we have for parents? When it comes to education, what things should they be doing, generally speaking, to look out for their child's welfare?
Yeah, well, I think the first answer comes right from the criminal statute. So there's certain things that we do expect, require parents to do in the state of Michigan. The truancy statute spells out once they hit a certain age, you have to start sending your child to school. It has to be continuous. And it has to be up until they reach a certain age. And there are all the other kinds of times that you can be excluded for homeschooling, et cetera. But the general obligation is to send your child to school. And it is a crime if you don't do it and then you're given notice and you still don't do it. The question, though, is not just what are we expecting of parents, but at what point can, in a child welfare proceeding, a trial court step in, take jurisdiction, remove the children, and you know, as happened in this case, get to the point where you put a service plan in place, and when they fail to comply with that service plan, you actually terminate that parent's rights permanently.
Let me just get back to sort of the line I was on, which is, I mean, here we have serious attendance issues and tardiness issues, and I understand that it's your position that that alone isn't enough, but surely that's a consideration, is it not? You just mentioned the truancy statute, so surely that's a consideration, right?
Of course, and trial courts do this all the time, is they make a determination, not just has the parent done something wrong. There's cases where there's substance abuse, or there's weapons in the home, or there's homelessness. And trial courts have to make a decision about, in the educational context, the same exact assessment. Not just are they missing school, but is it impacting the children in some way? And you can do that by introducing.
Well, before we get to that, to the impact, that I know your position is that there has to be harm, but I'm just trying to understand it. In this case, the parents didn't participate. I don't think they didn't testify at the adjudication hearing, and so there's no evidence really that they did anything to help with their children's education. And instead, the evidence is, in addition to the absences and the tardiness, the evidence is essentially that their involvement in their children's education, as I understand it, was zero. They didn't wake them or dress them for school. They didn't make them do their homework. The children didn't do their homework. They didn't make sure that they attended school or attended on time. And they didn't review or sign the report cards. So do you agree that here we have zero evidence that the parents had any involvement in the children's education, or am I missing something from the record below?
Respectfully, I think you are missing something. This isn't a case in which the children never went to school. This is a case in which the children didn't go to school as often as the average student. So they still went 75% of the time.
Let me just jump in. I don't want to argue the facts with you. I'm assuming that they attended 75% of the time in school, and then on top of that, they had a bunch of times when they did attend, but they were tardy. Isn't that what the record shows?
There were additional times they were tardy, yes. But again, if the trial court makes a determination that we've gotten to the point where it's so chronic that it's impacting the children, that's a finding that the trial court can make. But the trial court can't presume it simply based on numbers. That's the error.
I mean, I think I understand your position. I'm just trying to understand here that it seems to me, just in a general sense, that when we talk about neglect, we're talking about somebody didn't do something that they're supposed to be doing, that society expects them to do. And I'm trying to understand what the parents here were doing. I think in your papers, you gave an example of a wealthy family goes on a vacation, and therefore their children have some absences from school, and we wouldn't say that they were they wouldn't meet the statute, or it wouldn't be fair if they didn't meet the statute. But I was sort of thinking that, well, if you went on vacation and took your kids away from school, but you could show evidence that you did everything else that you're supposed to do. You took homework with you. You made sure they didn't have other absences or tardinesses. You signed the report cards. You made sure they did their homework. You woke them up and dressed them for school, made sure they got there on time. Then the parents would have sort of an argument. Here, there is no sort of, I don't think, any evidence that the parents did anything to tend to their children's educational needs, unless I'm missing something.
Well, I think that the whole point of the family that goes on vacation is that all those facts that you provided there would be evidence of how there's no impact on the children. The burden can't be shifted to the family to say, prove that you're doing something right. The burden is on the state to say that you've neglected these children, and that's the failure here.
I mean, when we look at the statutory definition, and I think we have to look at 722.602D, neglect means harm, which, harm or hurting a child's health or welfare. Welfare is well-being, I think. And it says, including the failure to provide adequate food, clothing, shelter, or medical care. So the statute sort of turns pretty quickly to failing to provide something that you should be providing, as an example. And I look back at the facts of this case, and I think, just like I think pretty quickly get to the failure to provide adequate food is going to cause harm to a child's health. Couldn't we also make the same inference that leaving it to the children, the 10-year-old to wake up the 5-year-old sibling on a daily basis for school, not making them do homework ever? They never turned in homework, these children, and never reviewing their report cards. Couldn't we draw an inference that that's harming the children?
Well, the testimony was only about one of the two children, and the testimony was from the teacher saying there were some optional homework assignments that were never turned in. So no, I actually wouldn't agree that that alone could constitute neglect. I'm sure there are many families who are making those decisions about. That's a big debate, homework. But more broadly, the examples of not providing food, not providing health care, when those result in harm, then you're very simply moved to neglect. If you're not providing food and it turns out that the grandmother is providing food, then there's no harm to the child. It's not asking a lot to say we're not going to find neglect in every case where a parent has done anything wrong. We're going to actually require to see some impact.
And what about the testimony that the teacher couldn't get a good assessment of the child, the learning needs and performance because of all the absences and the missed assessments? Doesn't that give rise to an inference of harm?
Not in this case, because the teacher simply testified she was concerned she wouldn't be able to assess. She actually offered the assessment that the child was still at grade level. So she actually was able to assess the child. She was worried about moving forward, what it might mean. It was entirely speculative.
And I guess this last question, doesn't your argument cause us to focus too much on outcomes as opposed to sort of inputs in the educational system? Meaning that, if you had parents who totally neglected everything that having to do with their child's education, but you had a child who was maybe brilliant and who could survive at grade level, you would say that's not neglect, even though that child, had they been given the correct or the right support, parenting support, would have been above average or excellent or thriving in their educational.
No, I wouldn't say that. I think that could be a case of neglect. Two pieces there. The first is it's very possible to introduce evidence in that situation that there's impact on the child, not in a non-educational way, just emotionally, socially, maybe physical safety. There's lots of ways to prove impact. The other is, I think it could be neglect if you have a child who's gifted and is 3 grade levels ahead, and then the parents fail to provide basic education, and that child falls back to grade level. That's a negative impact on that child. That could constitute neglect.
All right, thank you, counsel.
Thank you, counsel. Ms. Bergmann.
Good morning, Your Honors. Heather Bergmann is appearing on behalf of the Department of Health and Human Services. I want to kind of catapult from some of the comments and questions from Justice Viviano, because I think that he has raised a lot of the issues that we think are relevant in this case. And this is a case of statutory interpretation. It's very clear, and the court having to look at the facts of the case and determine whether they meet the statute. I'd remind the court what the standard is, preponderance of the evidence. So when you're looking at the evidence that the trial court considered, you have to say, does what he heard outweigh anything that would have been presented or the inference against neglect? And I want to touch on, too, the idea that I don't think that the record is being accurately represented, that even if a court does not adopt my first argument, that I think that there's a strong argument that you can presume neglect, I think that the record clearly shows evidence of neglect. And when you look at the statute itself, the statute talks about a parent not providing proper or necessary education. The statute then goes on to define what proper education is. And I don't think there's any issue here that the school that these children were attending was providing proper education. So then you look at what's necessary. And I think that looking at the fact that there's a compulsory education statute in our state, you could say that the legislature has deemed education as necessary. So you've got proper and you've got necessary education here. And so was the child harmed by not attending school? We've got a child here, actually 2 children. There was some reference in the amici brief that the number of absences included after the children were removed. That is not true. If you look at the preliminary hearing, the number of days was counted up to the day before the day of removal. So we're not adding days once these children were removed from the parents' care. So in summary, the children were missing 1 out of 4 days of school. And as I noted too in my brief, there were countless then, or an additional number of tardiness. So you've got another at least 10% where they're not getting a full day education. So the fact that a child's missing that much school, you certainly can presume harm. So do they have to be really smart to say that they're going to be harmed because their education is not being 100%? I don't think that that's the way you look at it. Every child, because the legislature has assumed education is such a necessary component of a child's well-being, to think that they're missing 25% of their days is really significant. The fact that the DHHS would not investigate a case simply based on missing school is a safeguard, I think. The respondents use it as something that they're going to say, well, look, the department doesn't even, their policy is that they won't even investigate these cases based on just absence. Well, I want to remind the court, this case did not come to the attention of the trial court simply because of educational neglect. This was the 3rd removal, and these parents had a history with the court and the department. And in fact, they had been removed 18 months at a prior removal from their parents' care. So they came to the court with drug issues. They came to the court with domestic violence, and the school was added actually at the preliminary hearing. So to say that there was an investigation just on education alone, that did not happen here. But the fact that the department won't investigate on education alone would actually protect against these cases where the respondent and the amici are concerned that we're going to wrap in all these children now in Michigan who may not be attending school because they're not getting online due to COVID.
Counsel, let me interrupt you and see what questions folks have, okay?
Oh, sure, thanks.
Thank you. Justice Bernstein.
Good morning, counsel. If you could just answer just the one question, I guess, that Justice Viviano was asking, and I'm just, seeing what your perspective on it is that, I guess my concern would be is that if I were to give a hypothetical where you have a socioeconomic situation where you have, let's say, a similar scenario taking place in like Bloomfield Hills, let's just say that the family, they had missed school, there was some job relocation, all those types of things. What is the standard that we're going to ultimately apply here? I mean, ultimately, I understand the fact pattern of this case, and I understand the issues that are at play. But the question I have is, in terms of developing a guideline for this, what's the guideline? What would the rule be? Is it 70%, 80%? Is it how many absences? What's the percentage? Is it a case by case? How do I develop a policy or, an opinion that would address your argument?
That's a great question, Your Honor. In fact, I was considering that very issue yesterday when I was reviewing this case. I think that there is really a question about what is chronic. When will the absences get to the number where they would become perhaps criminal? Or in this case of concern to a trial court who's looking at assuming jurisdiction in a neglect case. I think that in a lot of regards, it would be case by case. And that's where I think we need to trust our trial judges. The statute reads as it reads, but I think that we would be really naive in thinking that a trial judge would not consider the peripheral circumstances in a given case. The respondents talk about the health and the death of the older sibling. Those are all certainly circumstances, but the judge also had other circumstances. Again, the prior cases. And while he did not end up finding a jurisdiction based on the other grounds, they certainly were there. There was some evidence that the court was able to look at. So I do think that we need to trust the judges at the trial level to apply the statute correctly. And if they don't, then there's the appellate process. But I don't think that there's the risk of a bunch of students being brought into the court system and being removed from their parents based on the fact that they went on vacation. This is something different. Again, this is 1 out of 4 days of school that these children are missing.
Okay, thank you, counsel.
Justice Clement.
Thank you. Before we get to the point of trusting the trial judges to look at these situations and make decisions, can you tell me if there's a case in Michigan or anywhere else where a court has explicitly said that chronic absenteeism, defined however, alone is sufficient to show educational neglect, even without any showing of harm?
Well, Your Honor, there obviously in this situation, the Court of Appeals relied on In re Nash. And as you can probably see from my briefing in this case, I did not rely on In re Nash. In all honesty, I don't think that case says what the Court of Appeals used it for. And I know that there's other cases that have relied on it that are unpublished, and those were brought to the court's attention, I believe, in the Mekai brief. But I do think that there is a strong argument for the fact that chronic absenteeism is enough, like I said, based on, and I'm basing it, Your Honor, on the plain language of the statute. But I don't want the court to lose sight of the fact that I do believe that there is evidence of harm here. In fact, in one of the most recent cases, In re Richardson from the Court of Appeals from 2019, the court there said that we're not just going to look at the undesirable acts of a parent, okay? That there has to be some showing of harm or actual risk of harm. And that's where I think our case falls squarely. I think that you can say that there's an actual risk of harm. And that was the very thing that the...
Can I interrupt real quick? Is it actual risk of harm or
Yes.
is it showing of harm?
No, the court in re Richardson said, and there's other cases actually that use these very words, but this is the case that I would rely on, that there must be some showing of harm or actual risk of harm to the child that results from the parent's acts. That's taken from In re Richardson. And that's, I think, the very thing that this teacher testified to. She said that due to the fact that the young child that was in first grade, that he'd missed so many assessments, she wasn't able to get a complete picture. She said he was performing at grade level, but with the caveat that I'm not getting a complete picture because he has missed so many of the assessments. And I will note too that she also said that his behavior had changed in recent weeks. So there is definitely a showing of harm. And I think you can say when a child misses 1 out of 4 days of school, that there's an actual risk of harm. So whether the court wants to go with the presumption of harm or not, there certainly is harm or an actual risk of harm on our record.
Thank you.
You're welcome.
Justice Cavanagh.
I just want to clarify. So you said that there were other circumstances, other concerns that brought these children into care. And so we can't look at the education just in a vacuum, the educational issue. And I think you've said this, but I want to clarify that the trial judge that we are trusting his or her, I don't even remember at this point,
Yes.
their assessment, the trial judge specifically rejected those other bases, correct? And the only basis for imposing jurisdiction and removing and eventually terminating this parent's right was the education the failure to provide or neglect education, correct? Wasn't the
Yep.
other bases?
You're right, Your Honor. So what my point was is this case did not come to the court's attention based on neglect alone. When CPS started investigating this case, it wasn't until they went to actually interview the 10-year-old daughter at school that they found out about the school issues. So it
Okay.
started as a drug and a DV case.
But they weren't substantiated by the time that the judge decided that. Okay, so my other question is, and I think it's a valid point, is that you're, reassuring that your position would not result in, children and families being hauled into court for, missing one, 1 out of 4, when they go on vacation or these type of things. I think the concern is that only if that's going to happen, it's not going to happen uniformly or equitably across all families in Michigan. There's a significant connection, I think, to poverty in these cases, and this in particular, such as somebody, perhaps this family that was suffering a number of issues and problems with that. As opposed to like the hypothetical that was offered of, taking them out 1 out of every 4 days over the course of a year for, a life education, by traveling to Europe or that. Is it and I understand in response to Justice Clement's question that there isn't a case really that suggests that. And the policy of the department is not to pull or investigate based only on education. Do you have, though, experience of other circumstances where, the department has acted on across all sort of geographic or socioeconomic levels against on this basis of education, just based solely on a level, whatever that may be, of absenteeism as opposed to harm or potential harm to a child?
Yeah, Your Honor, I think that there's some good points that you raise in your question. And, I want to note that there was no equal protection issue raised here for the court. So the statute itself isn't being challenged on equal protection grounds, but I do appreciate that there would be concerns. But Your Honor, I don't think that there are any different concerns than we would have with regard to a parent not able to provide a home. Obviously, those issues are going to, I think, more greatly impact parents who are suffering from poverty. Or what about providing food to a child? You still have to look at the fact that children have needs, and these basic needs must be met. And again, I think that's where the plan comes into place, the case service plan. These parents aren't just left to fend for themselves. They come within the jurisdiction, and the hope is that these families will be reunited through services. And a lot of times the services that we see are just those, providing folks who don't have the means or the resources to have access to what they need to get back on their feet. But I don't know of any specific case. And perhaps we go back to the question of what does chronic mean? How many absences are too many? And that's where it's hard, because it's not defined anywhere. Even in the compulsory education statutes, it's not defined. But I certainly think that we have to read the statute as it is. If it's unconstitutional, that might be left for another day. I don't think that it is. Again, I think that there's a lot of issues that come before trial court with neglect and abuse cases that are predominantly poverty driven, but the court still deals with them effectively.
Okay, and then just the last one, and I understand we have to deal with the statute as written. And I will admit that I think it strikes me as odd the way the statute is written. I think it says, when a person neglects or refuses to provide proper education, using neglect as a verb, right? And but then it says specifically, as used in this subdivision, neglect means that term as defined in 722.602. And that specific definition links harm to the child. So doesn't that tell us sort of exactly the position that the father is making here, is that the burden is on the state to prove harm to the child?
I think that I agree. The statutes, I think, are difficult because you're right, they do use neglect. And they even do it in 722.602. It seems like that statute, as I argued, really makes a distinction between intentional behavior and non-intentional behavior, because they still say it's just harm and they don't define harm, as respondents have noted in their pleadings. But no, I think that you still have, again, because you say that education, like surgical or medical or support or any other things that are necessary for a child's health or welfare, as the statute indicates, once you've got proper education and you've got necessary education, I think that there's a strong argument that I've made that you can presume harm, or as in Richardson says, an actual risk of harm when you remove those important parts of rearing a child. But I do think, again, the record clearly supports that there was harm in this case. So again, if you don't go with the presumption, the record is clearly sufficient to show that there was harm, or at least an actual risk of harm.
Okay, thank you.
You're welcome.
Justice Welch?
Yes, thank you. I do just have one question. Ms. Bergmann, you did specifically make reference, obviously, a few times to the compulsory education statute in our state, and obviously made reference to that, showing the value we place upon education. Did that statute come into play at all in this case?
No, it did not. It did not.
Should that matter?
No, I don't think so. I think it just, I use the statute, Your Honor, to show, we looking at the legislature's intent in passing a statute. And I think that it's relevant how what other statutes the legislature has passed on the same topic. And the fact that they're requiring participation in school, I think, is indicative that they deem education as essential. And that's what I've used it for.
Thank you.
Justice Zahra?
Thank you. Justice Cavanagh asked a good portion of the questions I intended to ask. But when you finished up with Justice Cavanagh, you said if you don't go with the presumption. What presumption are you referencing?
Your Honor, I had argued that I thought that the statute as worded, you pretty much could presume that if a child is not receiving proper and necessary education, there's harm, just based on how the statute's worded.
I see. And recently we did away with the Hatcher standard for in verante. Does that not do away with any sort of attempt to presume anything? Don't we have to actually have actual evidence of harm now?
Yeah, I think that, especially in light of the In re Richardson, and like I said, I threw that out there because I think that it shows the legislature's intent to put education right at the top with medical support, surgical. And so that's where I started my argument, with the idea that I believe that, not that you could presume harm, that there is none, but that with an absence of education, you've got harm. That's why education is required in the state of Michigan, that you send your child to school. Because if a person is not educated, you can, I believe, presume harm. Whether, I know that presumption is like a legally charged word, but there is harm when you miss 1 out of 4 days. And again, I don't know where we want to put that level. Is it harm if you miss 1 out of 6 days? Is it harm if you miss 1 out of 10 days? I don't know. I don't know the answer to that question. But I started with the idea that based on the plain language of the statute and other tenets of statutory interpretation, I wanted the court to know that it's our position that the legislature has put education up there at the top. And when you look at the list in the kind of the catch-all phrase in 712A.2 subparagraph B1, it says, or other care necessary for his or her health or morals. That almost is the exact same language that the definition of 722.602 talks about when they say harm, what is harm or what is neglect. But again, I think that the record does show evidence of harm here.
Thank you.
Justice Viviano.
Thank you, counsel. Can you just help us understand as a practical matter where this case, what would happen next if we were to reverse the Court of Appeals and along the lines of Judge Reardon's dissent?
Yeah, it's an interesting question too, because so typically the other cases that I've seen that have been reversed based on the adjudication, they go back for further proceedings. So, you know, you've got the idea, and when I first started researching this issue, I was looking at cases, you know, with a preliminary examination, if you've got a bind over issue, but then the jury ultimately finds sufficient evidence to convict, the issue on the bind over is moot. So I was like, oh, wait, is this happen, you know, also in termination cases where you maybe have an error with the adjudication, but then you have a proper termination. And then I came up across, obviously, Ferranti and then the more recent case, Peterson. And there's a lot of issues you kind of that go back and forth. And I even entertained the idea, Your Honor, that, well, what if you have an adjudication here based on neglect alone, and the judge says, I don't believe there's any evidence of anything else. Can you have an adjudication that is right result, wrong reasons? Because I think that it's arguable here that we did have other evidence that was support, at least by a preponderance, that these children were suffering neglect for other reasons.
Procedurally, as I understand it, the mother was terminated also, but she didn't challenge the adjudication. Is that right?
She did not. She did not. And then the father, in this case, did not challenge the termination.
And there was further evidence that may bear on the father's fitness in terms of positive drug tests and mental health issues and ability to maintain a stable home that sort of came up after the adjudication phase, right?
Correct. And there was some evidence too of the educational issue that was also raised during the preliminary hearing. And so there was some evidence there that, again, that was what supported the prosecutor asking to add that ground after the preliminary hearing had concluded. So there is evidence.
The children are in foster care now?
I'm not sure, Your Honor. I don't know what the last report, I know that the foster care family that they were with during the pendency of this case was the same foster care family that they were with during the prior removal. I could look up really quick whether they
no, that's okay. But they're not awaiting, or the foster care family they're with, my understanding is not wanting to adopt them, right? So they're not in a sort of headed to a permanent placement yet.
That was the last order that I can recall, Your Honor. Yes, that they were not looking for placement, the foster family.
All right, thank you, counsel.
Thank you both. You have, Mr. Pinto, I'm sorry, we used up all your time, but we heard lots of excellent contributions from both of you, and we appreciate it. The case will be submitted. Thank you very much.